So let's jump right in. Think about buying a classic car for a second. You'd want to see the whole history, right? Every owner, every little repair, the whole paper trail. Now picture buying a brand new car. It just comes with a single, simple registration document. Well, that's kind of the difference between the old world of unregistered land and our modern system. And today, we are taking a deep dive into that classic car, the complex and sometimes really treacherous world of unregistered land.
And that's really the heart of the problem, isn't it? For anyone buying unregistered land, this is the fundamental question. It's not like you can just check some central database. Nope. You are on a historical detective mission. And trust me, if you miss a single clue, someone else's rights could suddenly become a very, very big problem for you.
So how in the world do we solve this puzzle? Well, don't worry, we've got a roadmap. We're going to start with the basics, then we'll tackle the one simple rule that exists, and from there, we'll navigate 3 really complex pathways for other types of rights. We'll even look at some genuinely shocking court cases along the way, before we finally understand why this whole system has, for the most part, been replaced. All right, first things first. When you're buying a piece of unregistered land, you have 2 absolutely crucial jobs to do before you can even begin to feel confident that the property is truly yours. Okay, so step 1 is all about proving the seller actually has the right to sell the property in the first place. This means you have to dig up what's called a good root of title, basically an unbroken chain of ownership documents that goes back at least 15 years. But it's step 2, which is what we're really focusing on today. That's about the ghosts in the machine, those hidden third-party rights that can just pop up and ambush you long after you think you're safe. This is where the real detective work kicks in. Okay, so before we get totally lost in the maze, there's one simple, really powerful rule you've got to know. It covers a specific category of rights, and you know what? It's beautifully straightforward.
And here it is. This is the golden rule for what we call legal interests. So think about things like a legal mortgage or a legal easement. That's just a formal right for someone to use part of your land, maybe for a driveway. If these rights are created properly with a formal document called a deed, they are basically unbreakable. They bind everyone forever. Any future buyer, including you, is stuck with them. There are no exceptions and no excuses.
But what about all the rights that aren't created with that formal deed? Well, those are called equitable interests, and this is where that simple, straight path ends, and we enter a pretty complicated maze. To figure out if one of these equitable rights is going to bind a buyer, we first have to figure out which of 3 very different pathways it follows.
And this is our map for the maze. Just think of it as 3 totally separate routes. Pathway 1 is for commercial-style rights, which, as you'll see, generally have to be registered. Pathway 2 is for family interests, like those under a trust, which can often be cleared away through a process called overreaching. And then Pathway 3 is the ancient safety net for literally everything else, the old doctrine of notice. We're going to walk down each one of these paths, starting with the most important one. So we'll kick things off with the most significant category, which is governed by the Land Charges Act. Now, this system was basically created to bring a little bit of certainty to these common commercial-style equitable interests. The rule, in theory, is super simple. You have to register your interest on a special list, or you risk losing it completely.
So the Act sorts these different interests into classes. You can see some of the big ones here. Class CIV, for example, that covers contracts to sell land like an option to purchase. D2E is for restrictive covenants. That's basically a promise not to do something on the land, like you can't build a second story. And Class F is a really crucial one. It protects a spouse's right to live in the family home, even if their name isn't on the official deeds. The main takeaway here is really simple. If you have one of these rights, you have to register it if you want it to be safe. And this slide right here shows the brutal black and white consequence of that. If your interest is registered, Section 198 of the Law of Property Act says it binds every single future purchaser. End of story. But if it's not registered, Section 199 says it's completely void. It just vanishes against a person who buys the legal estate for money. And as we're about to see, the courts have been incredibly strict about this. This brings us to a really famous case, Hollington Brothers Rhodes v. Rhodes. The facts are pretty simple. A buyer agreed to buy a property, and they absolutely knew there was a tenant with an equitable lease. The tenant unfortunately hadn't registered their interest as a land charge. The buyer even got a lower price because of the tenant. Seems pretty unfair to kick them out, right?
Well, the court's decision was absolutely ruthless. They said it didn't matter one bit that the buyer knew about the lease, it didn't matter that they got a discount on the price, the tenant hadn't registered their interest, so legally, it was void, it was gone. And this case established a core, brutal principle. When it comes to land charges, the register is everything. What you personally know is completely irrelevant.
Now, if you thought that was harsh, you need to hear about Midland Bank v. Green. Here's the story. A father gave his son an option to purchase the family farm, a classic estate contract. But the son, he forgot to register it. Later on, after a big family fight, the father sold the farm, which was worth £40,000, to his wife for a measly £500. And he did it with the clear, obvious intention of destroying his son's option.
And unbelievably, the court sided with the wife. The son's unregistered option was void. This shocking case established two more ruthless rules. First, the buyer's motive, even if it's completely malicious, doesn't matter. And second, as long as some kind of money or money's worth is paid, the court will not ask if it's a fair price. Just £500 was enough to completely wipe out the son's claim to a $40,000 farm.
But there is one tiny loophole. The case of Sainsbury shows a very specific situation where an unregistered right can actually survive. So here's what happened. A seller, let's call him H, never actually got the full legal title to the property. He only ever held the equitable title. He then granted an option to Sainsbury's, who, you guessed it, failed to register it. Then H sold his equitable title to another company, Olympia. So, did Olympia destroy the option? The court said no. But why? Because the rule only voids an interest against the purchaser of a legal estate. Since Olympia only ever bought an equitable estate, Sainsbury's unregistered option survived. It's a really fine distinction, but it can make all the difference.
Okay, so that's the wild world of registrable land charges. But what about interests that you can't register there, like the rights of a beneficiary under a family trust? Well, for that, we have to turn to our second and third pathways.
The main tool here is something called overreaching. It's actually a pretty clever mechanism designed to protect both the buyer and the people in the trust, the beneficiaries. When a property held in a trust is sold, overreaching allows the buyer to take that property completely free of the beneficiary's claims. Now, their rights aren't destroyed, they just cleverly detach from the land itself and reattach to the money the buyer paid. So the beneficiaries now have a claim to the cash, and the buyer gets a clean title to the house. Everybody wins.
So how does a buyer make sure that this process actually works? Well, the law provides a magic number, and that number is 2. For overreaching to be successful, the buyer must pay the purchase money to at least 2 trustees. This is a super important safeguard that's designed to prevent a single fraudulent trustee from just running off with all the family's money.
And this, of course, raises the big, obvious question. What happens if you don't follow that rule? What if there's only one trustee to pay the money to? Well, in that case, overreaching fails. The beneficiary's interest is not swept off the land. It stays right where it is. And that means we have to fall back on our third and final pathway, the oldest rule in the book.
This is the doctrine of notice. It really is a last resort. If an interest can't be registered as a land charge and it hasn't been overreached, it will bind a purchaser unless they can prove they meet this very special test. They have to be what lawyers sometimes call equity's darling, a bona fide purchaser who had no notice of the right. And this means they had no actual notice, nobody told them about it, no imputed notice, their lawyer or agent wasn't told, and crucially, no constructive notice, meaning they couldn't have discovered the interest by making the normal inspections a reasonable person would have made.
So, after navigating that whole maze of rules and cases and exceptions, let's just zoom out for a second and ask the big question. Why? Why was this incredibly complicated system created in the first place? And more importantly, why has it been almost completely abandoned?
So what is the core problem with this whole system? Well, it's a messy, really dangerous patchwork of rules. You've got land charges that are registered against people's names, not the property itself, which makes them really hard to find. You've got these brutal all-or-nothing consequences we saw in the Midland Bank case. And then you fall back on this vague old idea of what a buyer should have known. It's just inefficient, it's uncertain, and it is incredibly risky for buyers. And that is exactly why, for the last century, English law has been moving everything over to a single central authoritative register of title.
Which leaves us with one final thought. While only a tiny fraction of land in England and Wales is still unregistered today, these old rules haven't just vanished.
They can still pop up when a title is registered for the very first time or when weird defects appear in the modern system. So you see, understanding these historical traps isn't just some boring academic exercise, it's a really vital piece of the puzzle for knowing what it truly means to own land.